Sued your doctor for medical malpractice, and during the course of your lawsuit, we will have an opportunity to go ahead and question the doctor whom you have sued. What happens if the doctor refuses to come to the attorney's office or to be available on a Zoom video call for the purposes of being questioned in a deposition? You want to know the answer? Come join me on this deserted island as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. There are a number of options that can occur if the doctor refuses to testify in a pretrial process known as a deposition. Lawyers also call this an examination before trial. This typically in pre-COVID times would take place in the doctor's attorney's office. During COVID times, it typically takes place on a Zoom video call. The doctor is on the call, the doctor's attorney is on the call, I am on the call, and a court stenographer is also on the call to record all of the questions that I ask and all of the answers that the doctor gives. The answers that the doctor gives represent his sworn testimony, and you may not know this, it carries the same exact weight as if he's testifying in court in front of a judge and in front of a jury. So the answers during a pretrial deposition is critically important. So now, what happens if the doctor chooses not to come for a deposition to answer questions that I ask him? A number of things will happen. Number one, I can ask the court to go ahead and strike the doctor's answers in the case. Now, what does that mean? When we first start a lawsuit, we prepare a document called a complaint. And the complaint sets forth various, we call them causes of action, various allegations that we make against the doctor and or hospital staff. And now, part of those allegations include negligence and malpractice, among other things. In response to those allegations, the doctor's attorney has to respond to those complaints. He has to respond and answer each of the allegations. And they do that in a document called an answer. Now, that's a very important part of this lawsuit. It's the beginning stage of any medical malpractice lawsuit. Now, lawyers also call that the pleadings. In other words, we plead that the doctor failed to do X, Y, and Z. And many times we don't go into exquisite detail, but we give general allegations of malpractice, of negligence. The doctor is required to go through each and every allegation and either admit it or deny it, or claim that he doesn't have enough information to answer it. If we ask the court to strike the defense's answer because he has failed to show up for a court-ordered deposition, the judge, if he agrees with us, can strike their answer. And what does that mean? It means now that the pleadings go unopposed, that our allegations, our complaint, really is unopposed. And they are basically admitting every single thing in our complaint. It's like going to the baseball game where the Mets are playing the Yankees and the Mets don't show up. The Yankees get an automatic win. It's like a default. Same thing here. If we were to go ahead and start the lawsuit and now we serve this complaint, which contains all of the allegations, and the defense, the doctor's attorney, fails to answer those allegations, we get an automatic win. And then ultimately we will have to go through the process of having a trial to determine how much money you are to receive as a result of the doctor's carelessness. So go back to the original question I asked. If the doctor refuses to voluntarily show up for this deposition, this pretrial question and answer session, I'm going to go ahead and ask the court either to strike the doctor's answers, or another option would be an order of preclusion, or what we call a conditional order of preclusion. Now, what does that mean? The doctor may have a number of excuses about why he is physically incapable or unable to appear for a deposition at a particular date at a particular time. If his attorney says, listen, the doctor wants to come in, but let's say he's sick, he's ill, he's physically incapable of doing so, okay, when do you expect him to be available so that now we can question him? And the attorney might offer up a suggestion and say, listen, we would like to provide a deposition, we would like to have the doctor testify within 60 days prior to this case going to trial. If we don't show up within that time period, the attorney offers, we will be precluded, prevented from providing any testimony or evidence by the doctor at the time of trial. So this is a very powerful tool that we can use if the doctor fails to show up for a deposition, because one of the most important parts of a deposition is to lock the doctor into his testimony, to understand exactly what he did and why, and to make sure that he does not change his testimony when the case gets to trial. So with pretrial questioning, now I have an answer from the doctor about why he did something. A year down the road, when your case comes up for trial, when I ask him the same exact question in front of the jury, now he will no longer be able to change that answer. Why? Because he's already testified to it under oath, and if he changes it, now he has contradicted himself. Having a pretrial deposition before we ever get to trial is a critically important component of the discovery process in a medical malpractice case. So let's go back to the various options if the doctor refuses to come in and testify. 1, we ask the court to strike the answers, which gives us an automatic win. That's number 1. And that is the most stringent option that we have. That is the most devastating option that the court has in order to strike the doctor's answer. The second one, which is also a compelling tool, is a conditional order of preclusion, which basically says, listen, if you guys don't show up when you say you're going to show up, you are now prevented from coming in and offering testimony at the time of trial. So now, when the case goes to trial, and we go ahead and put on our witnesses and put on our evidence, the doctor will not be able to oppose using his own words and his own testimony or contradict anything that you have said. Why? Because he has failed to show up for his pretrial deposition. And that is a powerful tool. So why do I share this quick information with you on this deserted island here in the Caribbean? I share it with you just to open your eyes to help you understand how these types of cases work. You know, I recognize you're likely watching this because you wanted to see the gorgeous scenery here. No, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.